All right. Can
Yes.
Great, thank you. I'm going to assume everybody's ready to go. But let me check with just two. Miss Crane, are you ready to go?
Yep, ready to go.
Okay, and Miss Boulay?
I'm ready.
Great, thank you. We are on the record in the Colorado Public Utilities Commission's proceeding number 24R-0559EG. My name is Connor Farley. I am the administrative law judge assigned to this proceeding. It is approximately 11 a.m. on March 4th, 2025. This remote public comment hearing is being webcast. This remote public comment hearing was scheduled in a notice of proposed rulemaking that will otherwise be referred to as a NOPR, which was decision number C24-0940 that issued on December 24th, 2024. This remote public comment hearing was scheduled to allow members of the public to provide comments regarding the proposed amended rules as set out in the NOPR. I want to welcome and thank each of you who are participating in this remote public comment hearing. I've already reviewed the written comments that have been submitted to date, and they're helpful, and I'm hopeful that today's remote public comment hearing will provide further comments that will aid me and the commission in getting to the right result in amending the rules in light of Senate Bill 23-292. Let me just say at the outset that if I mispronounce anybody's name or refer to someone by an incorrect pronoun, I apologize and mean no disrespect. Just please simply correct me, and I will endeavor to get it right from then on out. Let me just cover for a few minutes the mechanics of the remote public comment hearing today. During this remote public comment hearing, let me just say somebody is not muted and I'm hearing a little bit of noise. Thank you. So during the remote public comment hearing today, you can provide oral comments to me regarding the proposed rules. You can also submit written comments. Many of you have already taken advantage of that opportunity. Both oral and written comments will be given the same weight. The Commission does not give any greater weight to oral or written comments. Now, that being said, the Commission prefers written comments because many of us are clearer and more persuasive in our written communications than in our oral communications. So that's the preference for the Commission, but we assign no different weight between oral and written comments. You can do both or either. As to written comments, if you would prefer to submit them, there are 4 ways that you can do so. First, you can send written comments by email to the following email address. Dora, D-O-R-A, _PUC, _website at state.co.us. The second way that you can provide written comments is through the Commission's website. The website address for the Commission is puc.colorado.gov. Once you hit that landing screen, you scroll down until you see the box labeled file a comment or complaint or something to that effect. We're not constantly up or changing our website, but it does change over time. The last time I looked, there was a button labeled file a comment or complaint. Once you click on that button, you will be taken to another page that includes a form into which you can put your written comments. And then when it's applicable, select this proceeding number, which is 24R-0559EG. Another way that you can provide written comments is through the good old US mail. The commission's mailing address is 1560 Broadway, Suite 250, Denver, Colorado 80202. And finally, you can also call a phone number at which you can leave an oral comment, which will be recorded. You can leave the oral comment in English or Spanish. And then after that, the comment will be transcribed, put into writing, and placed into this proceeding. The phone number to call to do so is 303-869-3490. That's 303-869-3490. Now, with all of these ways of submitting written comments, it's imperative that you include at the outset of your written comments this proceeding number, which again is 24R-0559EG. It's imperative that you do that so that our administrative folks at the commission can place your written comments in the correct proceeding in our e-filing system. So if you want to provide oral comments today, again, they're welcome. Please follow these steps. First, most of you have already done this, it looks like, probably all of you. Change your Zoom name to your first and last name. This is important for clear record and so I can call on you. Use the raise hand Zoom feature to signal you wish to speak. To do so, click the reactions button down at the bottom of your screen and raise your hand. If you no longer wish to speak, please lower your hand using the same process. Please remain on mute with your camera turned off until your name is called. If you do not know how to use the raise hand feature, you may instead turn on your video to signal that you wish to speak. Video, and please begin your comments by stating your first and last name. That's important so that Ms. Boulay, our court reporter, can get an accurate record or transcript of everything that's said while we're on the record today. And speaking of Ms. Boulay, when you do speak, please remember that she is working hard to get an accurate transcript of everything that is said while we're on the record today. Try to speak slowly and clearly. I may interrupt you and ask you to repeat yourself or slow down to aid Ms. Boulay. All of our statements while we're on the record during this remote public comment hearing need to be verbal. You can't shake your head one way or the other because that doesn't show up on a written transcript. Please, let's try to avoid talking over top of each other because, again, that's very difficult for Ms. Boulay to transcribe when we're both talking at the same time. So, for example, if I ask you a question, you may understand where I'm going with my question, and you may be inclined to jump in to answer the question before I'm done. Please try to refrain from doing that. And I, of course, will attempt to refrain from interrupting you or speaking over top of you. If somebody covers all the points you intended to include in your comments, please feel free during your comments to merely state that you agree with the points made by that person. You don't need to reiterate them, but if you want to, you may. So at the outset of your comments, as I noted, please state your name and who you represent so that we can follow later on in the transcript of who said what and who you're representing. Okay, that's it for my preliminaries. Are there any preliminary issues that anybody would like me to address before we dive in today? Okay, I'm not seeing anybody jump up, so let me just tell you what my plan is for today. First of all, I'd like to take any comment that anybody would like to offer essentially about how to handle this proceeding. The Senate bill that I referenced previously 23-292 is fairly broad ranging, and includes requirements that are new for the commission and require a lot of thoughtfulness on our behalf in trying to craft these rules to be as true to that legislation as possible. I'm not planning on addressing all issues today. I'm going to try to keep it narrow for purposes of this first meeting. At the end of this hearing, I'm going to continue it to a later date so that we can continue on with this process. But I'm willing to listen to any thoughts that anybody may have regarding how to handle this proceeding so that we get through this as efficiently and comprehensively as possible and get the best possible rules, again, that are that follow Senate Bill 23-292. So that's the first thing I want to do in this proceeding. After that, I'm going to take just any additional comments that any participant wants to make, either regarding the comments that have been submitted already in writing or otherwise. And then after that, today I'm going to focus primarily on the definition of energy sector public works projects, or ESPW as we like to call them. And I'll have some thoughts and questions for folks on that front. And hopefully the discussion will be robust and helpful, and I'm sure it will be. And then finally, like I said, I'm going to continue the hearing and issue an interim decision memorializing the continuance of the hearing and covering at least some of the topics that we address here today. So with that, that's my plan for today. So let me just jump right in and welcome any comments from anybody regarding how to handle this proceeding in the most efficient and comprehensive way possible that yields rules that honor as closely as possible the letter and spirit of Senate Bill 23-292. So does anybody have any thoughts about that? I'm not seeing anybody jumping up and offering anything. So let me just note, I see that Ms. Concelia is on here. And I read with interest, I think it was in the Labor Coalition's reply comments on page 4, in which at least a suggestion was made that we, I'll just read it, focus first on the procurement or bidding process and request suggestions from the utilities as to the form of contracts. And then Ms. Concelia, I think you went on to say something to the effect that public service and perhaps other utilities, quote, have recently had experience with enforcing BVEM through approved forms of contracts required by commission order to be used in their procurement in the electric resource procurement process. So can you elaborate on that at all, and at what point? I know you said in your reply comments that it might be helpful to focus on that first. I've suggested starting at the definitional level at this point and moving on from there. So in light of that, do you have any further thoughts?
Your Honor, who is also on the Zoom meeting with me is Gary Arnold, who is head of the pipe fitters union, and he was intimately involved in negotiating the contracts, or the legislation, I'm sorry. And I think it might be helpful if Gary could explain from labor how the definition of energy sector public works project should work. And then we also have had some discussions with Xcel Energy about some ways to put some criteria in that would be proscriptive and prescriptive at both the beginning of the bidding process and towards the end. And I don't know if Mr. Eiley wants to chat about that or somebody from Xcel, but I think it would be helpful to hear from those two folks.
Okay. So Mr. Arnold, would you like to speak? Welcome, by the way. Thanks for being here and helping me out with this rule language and understanding Senate Bill 23-292 better. So why don't you go ahead, either consistent with what Ms. Concealia said or otherwise.
Thank you, Your Honor. Happy to explain. We did work a lot on Senate Bill 23-292. And really, the intent and purpose from our perspective was to make sure that we were covering labor requirements for generation, transmission, projects in the energy sector that were utilizing either, taxpayer dollars or ratepayer dollars, and maximize the value to the state of Colorado and to residents and specifically workers. And so requiring prevailing wages, apprenticeship utilization, with apprenticeship programs that have a proven track record of actually graduating apprentices into journey workers and allowing folks to reach those good middle class, family sustaining jobs that those projects can provide. And so in the simplest forms, that's really the intention here. I was happy to have conversations with Mr. Eiley and Piesco on how do we make sure that when we go through the procurement process that we're really upholding those labor standards and regardless of kind of how those projects are coming, whether that be self builds or projects through independent power producers and power purchase agreements, that we're really finding ways to meet the intent of the legislation. And I thought they certainly had some good ideas on how to set the table there in phase one, and then make sure we were kind of following up on that in phase two to ensure that these projects are utilizing local residents. Those local residents have access to industry standard wages and benefits, health and retirement benefits, and bona fide training programs, like registered apprenticeship programs that do have a proven track record of actually graduating folks from apprentices into journey workers. And so would be happy to defer to Mr. Eiley, and but happy to answer any questions that you might have further on. Thank you, sir.
Thank you, Mr. Arnold. Mr. Eiley, do you want to weigh in on the discussions that you've had with Mr. Arnold and his colleagues?
Sure. I think I'll respond a little bit on process grounds for you, and then maybe a little bit on substantive grounds, and then we can you can kind of decide how far you want to go with that. I'd say from Xcel's standpoint, just at least procedurally, it makes sense to allow some further comment in the form of potential red lines. I know that's from rulemakings. I know that can be pretty helpful for the rule drafters. It may make sense to have, again, like solicit more specific red lines, which you haven't received from us, admittedly, yet, and maybe a further round of proposed rule for further comment at that point. But all that said, maybe another process point. We very recently, after the first rounds of comments, we did speak with Mr. Arnold and Ms. Concealia a little bit about some concepts that we've been thinking about how to implement these rules, especially across the ERP process. So in the body of the rules, I think that's primarily in section 3211 and 3611 by my read of this. Happy to share some of that whenever that makes sense. We can do that earlier or later in your process here. I'm happy to do either at your pleasure.
Well, while we're here, why don't we just do it now? Because I don't want to lose sight of these discussions and lose the benefit of the discussions as well. So why don't you go ahead, Mr. Ilion, on that discussion?
Thank you, sir. let me say this up front. This does represent some preliminary discussions, which we feel have some positive potential with Ms. Concilia and Mr. Arnold representing what I believe is called the Labor Coalition. We have introduced these to a couple of other parties, but I won't name them at this point, and I'll let them speak up if they wish. Very early conversations with those parties, but all that said, in essence, Ms. Concilia gave me a good lead off here. The ERP process has phase 1 and phase 2 in simplest terms. And I know many people here are familiar with that, but just we'll start with that. In essence, phase 1 seeks to set up the parameters under which you conduct a request for proposals, which turn into bids. And that really kicks off phase 2 when we have actual bids, we assemble portfolios, and where the commission approves actual portfolios. So each one of those processes roughly a year. We're seeking to address this bill and the intent and spirit of frankly, the existing statute, as well as the statute modified by Senate Bill 23-292 with this proposal. And it is strongly influenced by our experiences implementing this statute. And I think it's been in 3 total forms at this point. There was an earlier version and it was modified a few years ago and then modified more recently in 2023. We've worked through that process in our ERP. Other utilities have done that too. But in essence, we're seeking to install really two steps here. One is to set some what we call bid qualification, and that would propose what is really a minimum viable bid in terms of the BBEM information that is contained in that bid. And we would propose to set that bid qualification through the utility making a proposal through its phase 1 process, and that's consistent with the phase 1 process. It's in the form of an application. We would propose, in essence, how we would apply those 6 statutory criteria that is in statute after Senate Bill 23-292 applied. So they're listed. I won't name them, but in essence, it would be our proposal for how to implement those 6 criteria, meaning what information would be required from all bidders, whether they're independent power providers or Xcel Energy in those bids. And if they don't meet that, it would be in the form of a minimum bid qualification process. So that's step 1. And then in the phase 2, that would be the portfolio evaluation process. And that would take the form of the utility evaluating the BBEM score, and that's hopefully across a complete set of data. That's what we're striving for by establishing that bid qualification and those minimum criteria. We would evaluate each bid, and as we assembled portfolios, we would apply in aggregates, whether it's an average or total score, that could be probably TBD, but it would essentially represent the entire portfolio. And we tend to bring forward, between 5 and 10 portfolios, maybe sometimes a bit more than that. There would be an aggregate score for each one of those. And then there would also be an identification for those, and to help the commission decide how to evaluate the BBM information. There would also be potentially provided an identification of how many bids were, say, in the lower quartile of the BBEM rating. So you get an average, and you'd also get an identification of essentially like how many bids are in the lower quartile. Sort of, less, I guess a less fulsome representation on BBEM. And that was important to the labor conversants in this participants in this discussion. So that in essence is it. It's all of about 1 page. I think we would represent that we'd be happy to work with any of the parties that have been active in this proceeding and start to see if we can turn that into red lines. Looking at the red lines that are already here, I see some parallels, certainly. It may be more evolution than wholesale change of what's in the red line rule at this point. But we would represent that we'd be happy to work with other parties and provide some further information, kind of maybe in the time frame of 2, 3, 4 weeks out is sort of roughly what we've been seeking. But let me stop there. I said a lot. Happy to take questions or responses.
Okay, so let me just understand this. I mean, so you've already been working with the Labor Coalition represented by Ms. Concilia. I mean, how based on what you've sketched out here, and I've taken notes, and it makes sense to me. I mean, it sounds like potentially a fairly significant rewrite of the proposed rules. Is that a fair characterization of what I'm hearing, or do you think it's more limited?
I'm still sort of evaluating that, but I think it's in 3211 and 3611 of the red lines. I think there'd be material changes to that process. I don't think they're very terribly far afield. It's just more emphasizing the as applied. I keep gravitating toward that phrase of as applied. Because where we sit, we've gone through the experience of trying to evaluate bids. Sometimes they simply don't provide some of the information. We've literally had one-page responses to the criteria that we put forward in the last ERP. And we want to try to make it a more fair evaluation metric for the commission ultimately. And they can kind of weigh that against the other factors they already considered in the ERP. But to your question, I think there could be somewhere between material and significant rewrite of 3211 and 3611. But I think that bears on a little bit further consensus building on exactly how this would work.
Okay. And you know, I understand and appreciate that the conversation, at least the participants that you're willing to identify at this point, are you and Miss Concelia. You're not limiting it to just the two of you. You're willing to open it up to all participants, it sounds like. Is that fair?
We'd be willing to try. The broader it gets, the harder it gets, but sometimes we succeed.
Understood. So you said, you know, 2 to 4 weeks to produce these red lines. Did I hear that correctly?
Yeah, I may amend that to 3 to 4, but
Yeah.
willing to take comments from others here too, at your pleasure, of course.
Yeah, yeah. And so I'm just trying to get down what I've heard from you and particularly be realistic about timing, particularly as the number of participants in these discussions increase. It's likely you'd need more time to try to reach consensus on red line rules. I mean, that's what I hear you saying is some trying to reach some consensus on what you've sketched out, and then present that consensus in the form of red line rules, and perhaps a written comment submitted with the red line. Is that fair?
Yes. Yes.
Okay. So I see that Ms. Cutzer raised her hand, but I also see that Ms. Concelia had popped up. Ms. Concelia, do you want to add anything to this before I turn to Ms. Cutzer?
Yes, please, Your Honor. I think, as you are aware, on a big ERP, the phase one and the bids that come in gets to be huge. And I think what labor is looking for, and I think at least Excel, is a comfort level that if they don't comply with whatever is in this rule, that they can, that the company can remove them from the bid pool. Because if they don't have that ability, it slows everything down because you're relitigating this again and again and again. And I think the process that we worked through in the Clean Energy Plan for Public Service, 21A 141, I think, which is still ongoing, was quite helpful in terms of giving the company a comfort level that they could reject bids that did not comply. And then there was the grading that occurred later with the labor experts. So it's that sort of thing we're trying to work into this rulemaking.
Okay, thank you for that. And Mr. Arnold, I see that you popped up and you were before Ms. Cutzer. I'm coming to you, Ms. Cutzer, in just a moment. Mr. Arnold, do you have anything to add?
Yes, sir. Thank you. I think the idea that Piesco is presenting certainly is welcome from the Labor Coalition. Really, we're trying to figure out how to make sure that best value employment metrics are measured and weighed in the decision-making process. We've really struggled over the years with best value employment metrics legislation requirements, and how to figure out how to execute those really, in a meaningful way. And that was a large part of the intention in our engagement in Senate Bill 292 is trying to recognize the fact that trying to measure some of these things is hard, and how can we make it a little bit simpler and make sure that it's fair and the evaluations happen. And so prevailing wages, for example, either they're being paid and required or they're not. So that really measures both a wage for workers, but also health and retirement benefits, because those prevailing wages kind of capture that entire piece. And then do you operate a registered apprenticeship program? Kind of yes or no. And then does, for those specific trades where there's a minimum graduation requirement completion rate for those programs, kind of a black and white situation where you really can do that evaluation and really see, are you doing it or you're not? And so that phase one approach where you're setting the floor and requirements, I think really gets to the heart and the intent of the legislation. And then on the back end in phase two, when we're doing a portfolio kind of evaluation on that, various options you have there, really kind of ties it all together. And so that's when the idea, kind of came up, why we thought it was an attractive solution to getting, the intentions of Senate Bill 292 implemented in a way that, folks can understand and is fair to all parties engaging. And so appreciate the time and happy to answer any questions or any other follow-up on that.
Thank you, Mr. Arnold. I think I understand, so no questions at this point. Let me turn to Ms. Cutzer. Go ahead, Ms. Cutzer.
Thank you, ALJ Farley. Just a couple of thoughts here from COSACIA, and I see Mr. Leger has his hand up as well. So we'll try to be brief here. So I'll preface these comments by saying we worked really hard with labor, as I said in our comments, to come up with a workable solution in SB 23-292. The renewable energy industry is on board with complying with prevailing wage apprenticeship and BVEM requirements. So my comments are really intended to take issue with the potential impacts to the competitive solicitation process, and not as a criticism or a desire on behalf of COSA or members to somehow avoid compliance with these requirements. We agree. We think they're important. We think that being a partner with labor is really critical to make a successful clean energy transition. And so I raise these items again through the spirit of maintaining Colorado's competitive solicitation process, not as a criticism to the underlying requirements themselves. So just saying that, a couple of things. We haven't seen the language that Mr. Eiley has been referring to. We are very concerned that overly prescriptive requirements, particularly at the phase one process, could be very difficult to comply with. And the reason for that is timing. Often at phase one, there's a lot of specific information that's just simply not available to bidders because they haven't entered into EPC contracts, engineering, procurement, construction. Chris can correct me if I got that wrong. Contracts, right? It's the people who actually go out and build the project. And that agreement is entered into after a bid is successful and it's moving down the process. So statistics like, if you're able to procure Colorado laborers, a lot of these are guesses at the bidding phase because you haven't actually gone out and hired the workers to go do the work. And so our members do the best that they can, but I'm very fearful that if these requirements at phase one in particular are too prescriptive and give the utility the ability to simply delete bids based on a failure to comply or a failure to not have all the information available, that we're going to be taking a lot of bids out of consideration that may otherwise be in the best interest of Colorado and ratepayers. So we need to be very careful about how we execute upon this language. I think we remain open to working with labor and Excel to see what they have to bring, but I'd flag that as a very key concern of something that we'd be worried about and guarding against in reviewing any language.
Okay. All right, Mr. Leger, welcome. And go ahead.
Thank you, Your Honor. Yeah, just would like to agree with Ellen on that portion of what is available when bids are put in by developers is, I think, really key to what should be put into rule. And I think that that is top of mind. I think developers want to put in bids that include all of the available information. And there's no question of that. We, along with Ellen and COSA, participated in the negotiations of SB 292, and really we're all in to make sure that Colorado's priority for BVEM is included. I think just being realistic about what's available is important. I think to bring to your attention, I think a couple of things are probably important. First, contracts are currently a live issue in the JTS ERP. And so I just want to bring to your attention that dichotomy of what is relevant to that docket versus what should be put into rule, I think is really important because they're both ongoing at the same time. So just considering that. As well as Ellen at COSA, Interwest has not seen the language that was described by Mr. Eiley, so we can't really comment on whether or not that those changes to rule, I think, would be reasonable from our perspective. But again, we really would like to make sure that these rules are enduring and make Colorado have the best possible procurement process. And I guess I would just also like to respond to one thing that Mr. Eiley said about referencing the CEP results as not including, this level of BVEM information. As Your Honor knows, and as the NOPR suggested, the Inflation Reduction Act was a significant driver of the information that is contained in 292. And so the IRA was not in effect at the time of the CEP. And so I think developers didn't have the bucket of tools available to them that they do now. So I just want to bring to attention that I think the difference in BVEM responses are going to be substantial because the IRA includes a wealth of requirements that all developers are going to be striving for IRA tax credits. And so I'll just leave it at that. Thank you.
Okay, and I have a follow-up question for both you and Ms. Kutzer. And Mr. Ely, I see your hand up. I'm going to get to you in a moment. So, I mean, your comments are suggesting that public service is differently situated from the entities that you two represent, in that public service may have the ability to comply with the rule, Ms. Kutzer, as you've called it, that's more prescriptive at the phase one level than perhaps the entities that you two represent. So I want to try to understand that a little bit more. Can you give me, am I right, number one? And number two, what are the differences and why are there are these differences? I can guess at the answers to these questions, but it's better to hear from both of you. And Mr. Ely, you'll be given an opportunity in just a moment as well. So Ms. Kutzer, I'll start with you, or Mr. Leger, whoever wants to go first. You two can decide.
Yeah, I'll start, and I'll say that I do not represent the company developed projects or that side of the business, which is independent from the regulated side of public services business. So the specifics of how those projects are developed are best directed, to the extent Mr. Eiley can answer them since he works in a different group, probably to the company. But there's sort of three different categories of renewable energy projects in the marketplace. There's an independent power producer that signs a PPA agreement with public service. They maintain ownership of the project and they sell power to public service. That's how that contract works. There's a build transfer arrangement where a developer might develop the project to COD and then transfer the project to public service. And then there's, of course, public services owned developed projects. And those are controlled by company personnel much earlier in the process than the BTA or the IPP projects. And so because of that, you may have company personnel with a bit more predictability about who those people are, where they're located, the types of jobs that they have. That information, in my opinion, is available to the company or its affiliates much sooner in the process than it may be for a BTA or an IPP. And again, being very careful here because I don't represent that side. So if I've gotten anything wrong, I'm happy to be corrected by Mr. Eiley, but that's my understanding. So drawing to the issue at hand here, the company's subsidiary or sister company would be much better suited to provide more robust information when it comes to some of these BVE metrics than some of the IPP and BTA developers would be, in our opinion. And Chris, please jump in if you want to add anything there.
Yes, thank you, Your Honor. Thank you, Ellen. I guess I add one thing to what Ellen had to say, which is I think that there is a fundamental difference between independent developers and the company, the utility, in terms of how they finance it and what their expectations are for being selected in the final portfolio. A lot of times a utility can put forth projects that are highly likely to be selected in a resource procurement. Whereas an independent developer potentially is one of, let's say 1,000 bids that were in the last RFP that may or may not be selected. And they don't have really almost any information on the viability of their bid compared to others. And so, for example, hiring labor ahead of selection is very unreasonable if you're one of 1,000. Whereas if you think of yourself as one of 6, it might be more reasonable. And so where they're at in their stage of development at the bid submission process, at the bid submission time, I think is extremely important for the independent developers. If there were an independent developer that had 100 projects in Colorado, they may be hiring labor to know that we're going to get X number of those, so we're going to start locking down various components, labor, that sort of thing. However, independent developers that have 1 project or 2 projects that their only off-takers are utilities in Colorado and they may or may not be selected, they're very likely not in that same ability to lock down those inputs in a way that the utility developer potentially may be able to.
So are these BTA and IPP developers? I mean, it sounds like they have a lot more information at the bid stage on costs. They're able to estimate that fairly accurately. But as to the BVE metrics, they just don't have, what you're saying is they don't have that information at the bid stage typically, at least for some of them. Is that what I'm hearing?
Excuse me, I didn't mean to cut you off. Yes, I think the answer is that's correct, and it depends on the metric. So let's use registered apprenticeship programs. I think for certain job classifications, it may be easier to answer that question. If you're looking at electricians, like there are well-documented, recognized registered apprenticeship programs. For some of the other craft labor job classifications, it may be a little bit harder for not only us, but the company too, to understand what's out there in terms of, registered apprenticeship programs in Colorado. These questions can be pretty difficult to answer. They're important to answer once a project is being built because it's very important for compliance, especially with the apprenticeship requirements in state law and under the IRA. But it's just type of information that can be a bit tricky to track down at the early stage. I think the same could be said just top of mind of percentage of Colorado laborers, right? Like you may not have your workforce hired, as Mr. Leger said, that early in the process. You don't know how many people come from Colorado versus perhaps are being hired from another state. Those sorts of things. And happy to dig into this in more detail, perhaps in writing when you have a little more time to research the specifics. But
Understood. Well, I appreciate it. Mr. Leger, did you want to say something else?
Ye-
Mr.
yes,
Eiley,
I
I know
do.
I'm coming to you. Go
Yes,
ahead, Mr. Leger.
thank you. I would say, the risk of the cost components is on that independent developer in those cases. So you bid into a PPA or a BTA, and if you are wrong about the cost components of those part and parcel, each piece of your bid, and there are hundreds of different moving parts to bids, then that risk is on that IPP or BTA developer. That estimates that they provide at the bid stage are that they're just estimates. So they'll do their best effort to estimate we need X number of labor classification Y. We need to pay X dollars for labor classification Y. However, when they go and contract those different components, they may be materially different. And that risk is on the independent developer. So yes, they have the information to provide a estimate, and that estimate is they're willing to stand on it in terms of their bid price, but having the specific details of what they're going to utilize in 3 years, 5 years is something that they don't have available to them. So that's where I would say the differential really is.
So, and what's the risk to the BTA and IPP developers of doing their level best on the BBE metrics at the bid stage, but just getting them wrong? I mean, not wrong at the time that they submit the bid, but um, wrong later in the process.
I think that comes to the heart of this dispute, Judge Farley. I think like we would be comfortable with requiring a best estimate, but if there's a corresponding ability for the utility to strike bids because the estimate is off, then
Right.
that's a problem. So that's where I think we need to find the balance point here, is allowing the independent developers and the company to be able to provide estimate information that's of high quality. We don't want it to be this one-page disaster that Mr. Eiley referred to. We want it to be meaningful and a good attempt to comply with the requirements. But what we're saying is, maybe an estimate at the bid phase.
Okay, thank you. Mr. Eiley, I'm going to come to you now. You've heard a lot. Go ahead.
All right, thank you. Several things, I think. First of all, want to acknowledge, of course, Ms. Kutzer and Mr. Leher did not see anything that we proposed here, and that's not out of any effort not to share. It's just quickly developing things, and kind of sometimes you start small and work your way out. So that's very fair. I did want to maybe clarify something, and again, like recognizing no ability of those parties to have seen this. Our intent with the thinking in our proposal is to establish those minimum criteria in phase one of the ERP. And I will, at risk of repetition or telling people things they already know, phase one is an application. It is a litigated process. So our thinking is to propose the minimum qualifying criteria in that phase one, and then allow the other parties capably representing themselves as they're doing today to participate in that litigated phase one process. And then I see a strong possibility of alignment on that through that phase one process. So we're to put a little different point on it, we're leaning less heavily on prescribing a lot of this in the rules here, and more on building into the rules a process to evaluate this in each phase one for each utility and across each resource plan. We would hope that some degree of consistency sort of emerges over time, but sometimes these issues shift over time, right? Like we have one of the criteria is domestic content, very strong focus nationally right now, right? That might be different in 10 years. We can't predict that. These rules might live that long. So again, like the emphasis is on establishing how to establish the minimum criteria to make those factors something that can be fairly evaluated in phase one, but with the input of all the parties that participate in phase one. So I just want to make that super clear. And that is sort of an area that I think we can continue to discuss with parties and hopefully build some consensus around. I do want to take some exception with some of the things I said, or some of the things that I heard. I think what you heard was a sort of a stark difference, or at least the way I heard it, in how IPPs develop projects versus how the company develop projects. I don't necessarily agree with that. The company has to go out and source labor. It has to go out and source design, engineer, construction resources. It has to go out and source the equipment, you know, and that's from companies that are exactly the same companies the IPPs are sourcing it from. So for a wind turbine or a gas turbine or solar panels or batteries, we are in the same market that the IPPs are in. We are doing very similar processes when the company develops its own projects. And yes, there are these sort of build transfer type projects where they start from the IPP community, and then there's a transfer process, an ownership transfer, if you will. I actually think there's more similarities than differences. I heard a little bit different message from that score. What I didn't hear also was there's an independent evaluator in this phase two process. There is a process where the commission evaluates all these bids. I differ with Mr. Leher in the statement about the probability of our winning bids or not. We bid just like anyone else bids, and our probability of winning is based on the competitiveness of our bid. That's going to be based on cost. That's going to be based on the type of resource it is, including the emissions, and that's going to be based on factors such as the BBEM factors. So I think we're more similarly situated than differently situated. But I'll leave on a more peaceful note, which is that, yeah, and I'll emphasize that the phase one is the process where we can work through these nuances and bring these different perspectives into those conversations, and the commission can decide what are those minimum criteria that are for the collection of data in phase one. I think that's what the commission would ultimately do under our proposal. And I'd probably encourage you to hear from labor as well as just the IPPs and utilities pushing on each other about how they develop projects. With respect, Your Honor.
Thank you. So let me just make a point of clarification and get any response you may want to provide, Mr. Eiley. I mean, what I heard Ms. Kutzer and Mr. Arnold basically saying, or I'm sorry, Mr. Leger, basically saying about the differences between you and the BTA and IPP developers is you know, you have a lot more experience in this particular market in Colorado. Yes, you're basically competing in the same markets for labor and hardware, but you just have a lot more experience and pre-existing relationships in both of those markets, but I think primarily labor. Than the BTA and IPP developers. So I hear what you're saying. You're basically competing in the same markets with them. But I think their point was, from what I heard, a little bit different, which was essentially you have more experience there. You know more about it. You have pre-existing relationships that you can rely on. So with that, I'll just give you the chance, Mr. Eiley, if you want to respond to that.
Thank you. I mean, again, these are nuances that can be worked through in that phase one. So respect some of that, certainly. And we may have some more experience in these markets with certain components of craft labor and similar. I would say that some of the IPPs have greater experience than us in some ways. I don't think this is a David and Goliath situation. I just looked at the market capitalization of one of the leading IPPs. and it's triple what Xcel Energy is. And I'm talking about Xcel across 8 states, not just the Colorado version of Xcel. There are IPPs here that we frankly didn't own any wind generation for more than 10 years. The IPPs built all of that across numerous projects before Xcel Energy ever entered that market as far as a generation builder and owner. So there is considerable experience among the IPPs operating in Colorado and the other states we serve in. But again, these are the things that can be sort of worked through in the nuances of an evaluation and what are the minimum data that can be provided in a phase one, or work through in the phase one to be provided in the phase two. I want to make that a very careful distinction. So thank you.
Okay. Yeah. Thank you, Mr. Eiley. So here's what I'm going to do. I have 3 remaining hands up. I think it was Miss Kutzer, Mr. Arnold, and then Mr. Sopkins. So Mr. Sopkin, I am going to get to you. I see you. And we'll get to you soon enough. So Miss Kutzer, why don't you go ahead?
Yeah, I just wanted to acknowledge that it's probably not helpful to be argumentative about language we haven't seen yet. So I'm going to try to minimize, but I
That
will
would be
say,
appreciated.
I will say Mr. Eiley suggested let's save this for a litigated issue in phase one. I think we'd be open to that, but we are seeing a trend where the company is pushing for conforming bid language in its phase one. I won't say anything other than that, but if that's the outcome here, we'd much rather develop a comprehensive policy in this rulemaking than try to fight it out year after year, ERP after ERP with Public Service or Black Hills or Tri-State. I don't think that's an effective use of the commission's time or the litigants' time. So if we're able to come up with a comprehensive policy about here's how phase one can look, here's how phase two can look, I do think there would be efficiencies gained long term for those future litigated proceedings. So, I look forward to continuing to work with Xcel, see what they put on the table, but I don't think kicking it to, the litigated proceeding necessarily saves the time that we're thinking. Thanks.
Okay, thank you. And I understand that. Mr. Arnold, why don't you go ahead?
Thank you, Your Honor. Just kind of briefly wanted to mention, one, I did enjoy working with Ms. Kutzer on Senate Bill 292 and through the legislative process, and appreciate their work on trying to come up with ways to make sure that the legislation is implemented effectively. Understand that it's going to be challenging to figure out in phase one, like the percentage of Colorado workers versus the importation of workers from out of state. But I think requiring that the prevailing wage and benefit package is paid is one of the ways that kind of ensures that happens. There's numerous studies that show that that's one of the greatest benefits of prevailing wage policies and those requirements. And that's because you're looking at the geographic area that the project's actually being built in and requiring that workers from various trades are going to be compensated in a wage and benefit package that prevails the preponderance of the time for the area. And so there's less incentive to import workers in from areas of the country with much lower cost of living, because you don't gain an economic competitive advantage when you require that policy to be in place. And so I think that helps. And I do look forward to working with all the parties throughout this process, because I think we can figure this out. But for like registered apprenticeships and utilization, it's hard to understand how a developer would come up with an accurate estimate without talking to contractors that would actually be executing work on site. And simply is, do you have a registered apprenticeship program, or is your company attached to a registered apprenticeship program? You also have the Colorado Apprenticeship Directory as a resource, which the State Apprenticeship Agency does a really great job of making sure that every single registered apprenticeship program in the state of Colorado is listed in that directory and listed by trade and by craft. So you could look up what is the registered programs for electrician, for pipe fitter, for laborer, for heavy equipment operators. And you can see every registered program that is operating in the state of Colorado. You'd also know which contractors are attached to those registered apprenticeship programs. So I think there's a tremendous amount of resources out there when it comes to trying to figure out like kind of who is available and where these various pieces can be made sure that you have that requirement in that phase one, kind of in that initial phase. But understand, obviously, like I said on the example for the exact percentage of Colorado workers versus out of state, having that requirement, the prevailing wages, I think helps solve some of that without getting into too far into the weeds where somebody maybe doesn't have the information in phase one. Thank you.
Thank you. I have a follow-up question for you, Mr. Arnold, and I kind of hesitate to ask it because I don't know exactly where it's going to go, and it's going to show how ignorant I am of this. But apprenticeship programs. It sounds like, based on what you said, that there's a possibility, at least, that a single apprenticeship program could be shared by multiple contractors / employers. Is that correct?
Yes, Your Honor. For example, our registered program, it is a multi-employer program. All of our signatory contractors participate in it. But on, say, the open shop side of things, CITC, I think, is a great example. There is numerous contractors that participate in that registered program over on the non-union side of things. So yes, very common.
Okay. All right. Well, that's good to know. Thank you for that, Mr. Arnold. Now, finally, to Mr. Sopkin, welcome. Please go ahead.
Good afternoon, Your Honor, by 3 minutes here. I just wanted to briefly interject that this dispute may be more than it appears, depending on how we go about it. I agree with much of what Mr. Eiley said, as well as what Ms. Kutzer said. It depends on how this is approached. If you're doing this as part of phase one and you're setting up what I would call procedural requirements rather than substantive requirements, as far as what a bidder must have, and the bidder can simply talk about, best estimates, what efforts are being made, those sorts of things. It seems to me that should be satisfactory at that phase. The more you get into absolute substantive requirements, you need a certain percentage of call-order workers, things like that. The more difficult it's going to be for whether it's utility owned or IPP or BTA, the more difficult that's going to be. So, in our own case, our last ERP, I believe we adjudged bids on a 100-point scale. 75 points was economic factors, 25 points were non-economic factors. And splitting those non-economic factors up, about 5 points were for BVEM. And if a bidder didn't bother to try to provide BVM information, they simply got a 0 on that score, 0 out of 5. But if they did attempt to comply and provide information, then they would get a score somewhere between 1 and 5. I think what is being suggested here is that if there's no attempt at all, in other words, that 0 score, then that could potentially throw out that bid. We might be comfortable with that. We'd probably want there to be some kind of opportunity to cure for the bidder. But again, it's more of a procedural than a substantive requirement. And if it's approached in that way, they're attempting to comply as best as they can, then the bid doesn't get thrown out. And as a very important matter, the economics of the bid don't get thrown out. Again, the economics of the bid were 75 points on our scale, and that's a very important issue. And so we should be careful about throwing out bids entirely that could be the most economic bid if they are attempting to comply as best as they can procedurally, with the BVM requirement, if that makes sense to you.
It does. I understand. Give me just a moment. So, Mr. Sopkin, maybe you said this towards the beginning of your comments, but this process proposed by Mr. Eiley and Ms. Concelia, would Black Hills be willing to participate?
Yeah, I mean, absolutely, we're willing to participate in the discussion. Again, we would like it to be such that the requirements are not so onerous as to throw out what might be very attractive bids economically.
Understood. Do you have any thoughts about how long the process would take. I mean, Mr. Eiley essentially said, I think we're at 3 to 4 weeks now to be able to file, hopefully red line rule showing consensus among participants and maybe identifying as well areas of continued disagreement. Do you have any thoughts about that? Do you think that's ambitious? What are your thoughts?
I think 3 to 4 weeks is entirely doable from our
Okay.
perspective.
Okay. All right. Ms. Concilia, I see that you turned on your videos, so go ahead if you have something to say. And thank you, Mr. Sopkin.
I did, and I appreciate the conversation. And as Mr. Eiley said, we only began discussing labor with Excel Friday evening, and everybody's busy doing other things. Mr. Sopkin and I've had technical conference on the Black Hills rate case, public services doing all sorts of things, so we can work together. I am troubled by a belief that these will not be substantive requirements, because in the past, the commission has not done a good job of implementing the BVM statute. And I would say, with all respect to some of the participants, there's been a little bit of BVEM whitewashing, that things didn't comply. And when you get then to the portfolios, you can really, because of how those are constructed, dilute the interests of labor. And what we need to keep in mind, it is Colorado ratepayers that are paying for all of this infrastructure. And labor just wants to make sure that they are included, and that was the purpose of the bill. So we will welcome the opportunity to work, and I think that the time frame Mr. Eiley has indicated would be helpful, and perhaps we can get some consensus or at least narrow some issues.
Okay. Thank you, Ms. Concilia. And the whole question about, how procedural versus substantive the requirements would be, I mean, obviously would be a subject for discussion amongst whoever participates in these discussions. Okay, well, and let me just continue on with just process and how to organize this. So, I'm inclined to give you all 4 weeks to do this, to try to maximize the likelihood of getting something really useful at the end of it, and as comprehensive as possible. So what do you think about me setting, a deadline today for you to engage in this process? And the deadline would then be basically a report to be filed with the commission in approximately a month. And then perhaps, opportunity for written comment from anybody who wants to provide it, both, again, initial and response, separated by a week or two, and then follow that up, with the continued public comment hearing. So I guess what I'd be thinking about, and I'm just thinking off the top of my head here, so we're at March 4th, a deadline for a report to be filed, just reporting back on what you've accomplished and hopefully providing redlined rules by April 4th, exactly a month from today, maybe the following week, whatever that deadline is. Then maybe 2 weeks after that for initial written comments for everybody to comment on hopefully additionally redlined rules, and then a week or two after that for response or reply comments, which will put us in early May. And then a continued public comment hearing then a week or two after that. So we're then talking about mid-May for the continued public comment hearing. Again, I'm doing this on the fly. I'm looking for reaction to that. So, and I'm not seeing anybody jump up. I see Mr. Eiley. Why don't you go ahead, Mr. Eiley?
We're still processing that, and certainly appreciate your improvising a process in real time. One thing we just wanted to clarify that this entire conversation has really been around the ERP process and
Right.
in 3211. So I think if the intended consensus is confined to that timing works pretty well from our standpoint. We'd see if there are other areas we can get alignment on to make this rule work for everyone. Given the priority here, it does seem like this is a lot of the substance of where the application becomes a little harder. But I think that general timing works.
Okay. And that was my intent as well. I mean, I'm not going to restrict what you're going to talk about in this process, but my expectation would be, I mean, you're biting off a pretty big portion just focusing on the ERP process here. So my expectation and hope would be that you would be able to, in the 4 weeks, basically comprehensively discuss with whoever participates that topic and hopefully reach some consensus at least on that topic and be able to report back in approximately a month. So, Ms. Concelia, I saw that you had popped up for a moment. I don't mean to put you on the spot if there's nothing else to say on this topic, but go ahead.
I think what's going on is Mr. Eiley, and my guess is Mr. Leger and Ms. Coutts are looking at all the scheduling that's going on in these other proceedings. The schedule that you've laid out is acceptable to labor, but I would defer to folks who are intensely involved with these other proceedings with deadlines in April.
Yes, and that makes sense to me. So why don't we do this? I mean, we've been going for approximately an hour and 15 minutes. We're at the lunch hour. Why don't we take a 45-minute recess until 1 o'clock for everybody to think about what I just proposed and talk with their colleagues to see, just get reaction and see whether this has any possibility of working. Why don't we do that? But I see that Ms. Cutzer popped up first, so why don't you go ahead?
Can I just recap what I heard to make the lunch conversations effective? So you're
Yes.
suggesting a status update and a red line, hopefully, rule submitted sometime near the 1st of April.
Yeah, I had said specifically April 4th or the following week, but yes.
Got it.
Go ahead.
And then 2 weeks after that, which would be the 18th, is responsive comments. Is that correct?
Yeah, I'd call them initial comments regarding the
Okay.
red line, and then I'd give the opportunity for reply comments, replying to the initial comments regarding the red line, just to be as comprehensive as possible.
Okay.
So yes, initial comments. Let me look at my calendar, and I'm glad that you're doing this because I didn't write any of this down. Yeah, so comments would be, let's say, April 18th. Responsive comments either April 25th or May 2nd. And then I'd need to look at my schedule and the commission schedule as well. But then I would think, the continued public comment hearing, let's say the week of May 12th.
So just a flag, May is pretty busy for a lot of the parties with hearings. It looks like the Piesco wildfire mitigation hearing is the first 2 weeks of May. It may not affect everyone who's involved in this rulemaking, but and then a few of us have some scattered additional one-day hearings. Probably can work within that, but it does look like May is a particularly busy month for hearings, at least based on my calendar.
Understood. And I had not looked at the commission calendar at this point. You know, I'm not wedded to this timing, and I want to be as efficient as possible in getting through this proceeding while doing justice to it. So, I mean, if we need to move the public comment hearing so that it's as productive as possible, the continued public comment hearing, you know, I'm certainly open to that.
Okay. Maybe we can talk among ourselves at lunch and come up with a suggestion.
Okay. That sounds fine with me. So I don't see anybody else who wants to contribute at this point. So um, let's let's recess until 1 o'clock. Thank you.
I can't. I can.
Yeah?
Yes.
I was going to tell you, Francis, you're a little quiet and hard to hear.
Yeah, I don't know what's going on. I appreciate that. Jack told me. Is this any better?
Yeah, this is good.
Okay.
Yeah, this is good.
I rearranged some stuff. Thank you.
It might be the platform. Zoom is different sometimes than Teams. Schedule-wise, our position is that the judge's calendar is probably okay. And if it needs to move farther out, not closer. For a number of reasons on our side.
Yeah, I think that's okay with labor. Gary told me that, you know, they don't want to go into June. They'd like to get this stuff resolved and implemented.
That's fair.
And
We were thinking we could file a notice or something if we can't meet that first date and we need another week or something to meet that first date. You know, and he can adjust the schedule.
Sorry, you are unmuted, so we are hearing
Hey, sorry,
you.
I was having some audio trouble. Can you repeat what was just said?
Hi, this is the legal assistant. You are being recorded on the live stream. We can hear you.
I did not. I'm sorry.
Oh, I don't have to be the calendar representative, but
We're generally okay with the ALJ's proposed schedule, just given all the other demands on the company in March and April.
Yeah,
Having a hearing in that May timeframe feels a little bit better to us. The only other thing is, you know, if we're not able to meet that April 4th date, we may need to have some flex, you know, there. It just depends on how the conversations go.
I think that works for Tri-State. We're very busy in March and April, so more time is preferable for us. My only change to what the ALJ suggested would be to move the initial comment deadline to April 23rd.
I think that's okay with labor as long as we're not kicking the actual hearing, you know, into
Ms. Concia, can you hear me?
Yes.
You are being recorded right now. You're
Um,
unmuted.
Question for the public service team. Do we need to be cognizant of getting these rules finalized before the phase 2 JTS kicks off? Or what is that date?
it's a good question, and I appreciate that Chris raised that sort of synchronization. I don't know off the top of my head here. Like, I imagine we'd be starting to follow those same rules in phase 2, but frankly, like, we're proposing to codify kind of what we did in the CEP in most ways, except for that dialogue in phase 1. We didn't start with that. So I don't know. Like, we probably have to do a little bit of diving to see exactly how this would work with phase 2.
Hey, folks, I just got a text that everything is live on the Zoom, that somebody is still on the Zoom right now. Francis, it sounds like it's you from what I'm seeing.
Really? I joined. Okay. Sorry. So you think I joined through Zoom other than through this invite?
We can actually hear all of you.
What I'm hearing
Yeah, we
is
can
you
still
have
hear you.
Zoom open and you're unmuted. So I think that it's rebroadcasting this conversation.
All right. Let me see if I can deal with that. I'm going to leave everything.
Okay, Ms. Crane, are you ready?
Ready?
Ms. Boulay?
I'm ready.
Great. We're back on the record in the remote public comment hearing in proceeding number 24R-0559EG. Before we broke, we had a lengthy conversation basically about initial process for this proceeding. And I won't summarize everything that we talked about before. I'll just turn to anybody who would like to tell me whether the schedule / process that we talked about before the lunch break, what any thoughts are about that. And I see that Mr. Eiley has popped up, so why don't you go ahead?
Thank you, Your Honor. Over the lunch break, we gathered COSA, Interwest, Fiesco, Tri-State, and the Labor Coalition. Apologies, we missed Black Hills there, and probably some other folks too. But the thoughts we had there were that your proposed schedule is pretty reasonable. There was basically a couple of suggestions that have a little bit of a cascade. So I'm happy to give initial and proposed dates if that's helpful to you.
Yes, that would be helpful.
Okay, so for the report and red line, you would propose April 4th.
Yep.
The group kept that, but noted that there may be some need for a little bit of extra time, but we don't know that yet, and we would file a notice if we needed a few days. For the initial comments, which I believe you would propose for April 18th, there was a request to move that to April 23rd. And then the rest just mostly cascade from there. For the reply comments, I believe you had proposed May 2nd. That would move out to May the 7th. For the hearing, your proposal was May 12th, and the thought was hold that potentially on May 19th or May 20th. But in any case, try to hold that in May for the requests of labor specifically. So that would be the counter proposal. We could provide that in writing if needed. Welcome any of the parties who participated in that to clarify anything.
Okay, I don't need that in writing. I just took it down. So all of that works for me. And I think my preference would be to hold the continued remote public comment hearing on Tuesday, May 20th, rather than Monday, May 19th. So all of that is fine with me. And as I said, I just want to give you all the best chance to either reach consensus on one end of the spectrum, the other end of the spectrum, not reach consensus, but identify differences more clearly. This is all fine with me. So why don't we go ahead and do that? And let me just read it back to you, Mr. Eiley. I have the report being due on, and with red lines, hopefully, on April 4th. You all may need some more time, in which case you'll just file something indicating as much. And initial comments on the report / red line, and I'm not going to limit it. Anything else you want to talk about is April 23rd. The reply comments would be May 7th. And then the continued remote public comment hearing would be on May 20th. Did I get that right?
Yes.
Okay.
Thank you.
So if anybody, it sounds like that's consensus, but I'm going to give anybody the opportunity to say what they'd like about that, if there is anything. All right, so not seeing that anybody has any further comments regarding process. Let me just ask at this point, does anybody have any additional comments that they'd like to make about, anything within the scope of this rulemaking? So I'm not seeing anybody, so I'm just going to ask a few clarifying questions. As I said, I wanted to discuss, and I'm not going to go into any detail on this at this point, but the definition of energy sector public works projects in 3001P and 4001Y. Mr. Eiley, I think this is directed to you. This was a comment that Public Service made in its initial comments. And I'll just read the primary sentence. Public Service urges the Commission to establish the filing of a CPCN application as the point in time to determine whether the project is an ESPW project. And I'm slightly confused by that, Mr. Eiley. I mean, not all ESPW projects would, or would they result in the filing of an application for a CPCN?
I'd actually like to call on Mr. Survey, who is in our General Counsel office for XL, if that's okay.
That's just fine. I didn't mean to put you on the spot.
No problem.
Mr. Survey, please go ahead. Do you understand my question, first of all?
Hi, Mr. Farley. Hi, Judge Farley. Yes, I believe I do understand your question. Just to clarify, Ryan Survey, I'm counsel for public service. So the issue that we identified is that it can be, the value of a project is not always known, with certainty, and that there are often estimate bands, right? So that, that we believe a project is of a certain amount, but at some point it might be higher, at some point it might be lower. And so at the time of a CPCN, at the time of the application filing is when we thought the value should be locked in. As I say that, I'm sensing that maybe I'm not actually getting at your question. Maybe it would be helpful if you could repeat it for me.
Yeah, and I'll have a follow-up on that. But so, it occurs to me, or at least the possibility, that a ESPW project, could be addressed solely within an ERP, but not in a CPCN application. Pinning the time at which to determine whether a project is an ESPW project solely as to the filing of a CPCN seems at least potentially problematic to me.
Thank you. Yes, for projects that would, go through the ERP process, I think that wouldn't necessarily make sense what I'd propose. What we're thinking is on the gas side, for a project that doesn't go through an ERP, where it's just the CPCN that would be a hook, that's when then it would be more of an issue of knowing, what the value of the project would be at the time of CPCN filing. Is that helpful?
Yes, I think I understand. Okay. And then regarding CPCN applications, I mean, my experience has been, you indicated the thought that the cost gets pretty well locked down by the time a CPCN application is filed. Did I understand that correctly?
Well, more that is the right time to establish what the value is, because at some point we need to lock it in, and that would make the most sense from a procedural standpoint.
Okay. All right. My experience has been with some CPCN applications in any event, they do fairly substantially predate the projected starting point for the project. And So I get a pretty, my experience has been that those applications have a pretty, it's surprisingly for me, wide range for the costs. And, sometimes in these CPCN applications, the applicant is not even really seeking a presumption of prudence. So in any event, I understand your point. I just am wondering exactly how lockdown costs are in CPCN applications, because like I said, my experience in at least some of them has been to the contrary.
Thank you for that. And, maybe it would be more helpful for us to provide more comments on that later in this proceeding.
Okay, and that's just fine. Why don't we leave it at that? So let me just move on briefly. I'm just hitting high points here. And this is a question for Tri-State from their initial comments. What I'd like some further explanation on is a sentence. I'm going to read it into the record. Proposed Rule 3001 P2 has been modified from the language in Section 24-92-303, which changes the scope of applicability, such as by whom utility customers funding is approved by. And that's on the second page of your initial comments. Hello and welcome, Mr. Hefner. So can you give me more specificity on that sentence?
Yeah, good afternoon, Your Honor. Dietrich Hefner on behalf of Tri-State. I think that the thrust of our comments in this area is in 24-92-303, the General Assembly gave us a pretty detailed definition of what an energy sector public works project is. And the way it's written, right, it's in 303.5, lowercase a, Roman 1 and Roman 2. Roman 1 is the rule that applies to investor-owned utilities, and Roman 2 is the one that brings in the cooperatives. And the way we read that is they're a little bit different. They're not exactly the same standard. And so the main thrust of our comments in this area about Rule 3001 P2 is, well, since we have this sort of nuanced definition from the General Assembly, can we just sort of cross-reference the definition that we've been given rather than try and paraphrase it, which we think maybe introduces some ambiguity or potentially even errors into what the General Assembly put forward.
Okay, so that comment, did I understand that correctly, is limited to proposed Rule 3001 P2, did you say?
Well, I think if you look at our red line, we've redlined the entirety of paragraph P to just make a cross-reference to the statute rather than trying to restate it within the rules.
Okay, understood. Okay, I'll look at that again more closely. So thank you for that.
Thank you.
I don't know if Mr. Sopkin is here. I have a quick question regarding a comment in Black Hill's reply comments. This is on page 4. And it's where you reference the $500,000 ratepayer funding demarcation line regarding a presumption of prudence. And Black Hills refers to that as arbitrary. And I'm trying to understand that. And I can't hear you, Mr. Sopkin. I don't see that you're muted.
Can you hear me now?
Yep, we can.
I think the suggestion was merely that the way it's phrased sounds like there's only a presumption of prudence if the project is 500,000 or more. I'm sure that's not what was intended, but perhaps a bit of wordsmithing can just make it clear that what we're really talking about here is there's a threshold of $500,000, not that the presumption of prudence is only extended to projects that exceed $500,000, if that makes sense.
So are you saying that it extends to any project regardless of the amount of the presumption of prudence?
When you say it extends to, what do you mean by it? I'm sorry, what I'm trying to say is that if you file a resource plan or a CPCN, a project does not have to be greater than $500,000 for there to be a presumption of prudence. That's all the point.
Okay,
That's it.
got it. Understood. Okay, that's helpful. So I intended to cover a lot more today, but I think I'm just going to call it at that in light of the process that we're going to embark on. So with that, let me just ask everybody if there are any further comments that anybody would like to provide at this time regarding anything we've talked about or anything else. So I'll pause for a moment or two. Okay, I'm not seeing anybody come up, so let me just thank you all for your participation today. I will issue an interim decision memorializing the process that we landed on today. That will come out in the next week or so. So look for that. Otherwise, the deadlines for the upcoming events are as we just talked about a few minutes ago. And with that, I'm going to continue this remote public comment hearing until May 20th at 11 a.m. So let me thank you again, and I'll see you all soon.